Hello, good afternoon. Welcome everybody to today's webinar from Fredrikson and Byron on structuring innovative hospital physician joint ventures and other arrangements. Always like to include a phrase like that, and other arrangements. It's similar to the phrase in the Constitution that says, and other high crimes and misdemeanors. I've got a couple of housekeeping things. Number one, my name's Steve Beck. With me today is my partner, Ryan Johnson. We're going to be spending just a little under an hour, and hopefully we'll have time for questions. In order to send us a question, look at the bottom of your screen to see the chat feature. You can hover over that, and the question will come to our computer, and we'll try to answer. If we see you asking a question that we think you shouldn't ask, we won't probably answer it, but we'll check with you later. Should the internet audio cut out, which it should not, but if your internet audio ceases to work, you can use the dial-in number that's been provided, so you can call in and get the audio even though something has gone crazy with your computer. I also want to tell a little bit about next month's webinar. It will be February 19th. And the topic is a rip snorter. It's what health lawyers and compliance personnel need to know about the opioid crisis and the laws affecting and coming out of it. That's going to be handled by Katie Ilton, Margie Amon, Pari Megara, Andrew Holm, Chelsea, and we're going to be covering prescribing, distributing, ECRA structuring, barriers to working in this area, regulation, reimbursement policies, a whole bucket of items involving the opioid crisis. And I think more and more folks are finding that the opioid area is a troubling, difficult area that is not something that healthcare providers who are used to the regulatory format they've got, oh, somebody's handing me the wand, are used to. So I'm going to be listening to that. I expect everybody will want to. It should be, as I say, a great one. So let's talk a little bit about what we're going to try to do today. We're going to go through a set of models that are inspired by quirks or interesting things in the law. And you may find that this is something that lawyers will find very interesting and that is full of trickiness. I think it's important to understand that what we're really trying to do here is to identify some areas that are maybe underused and that provide some opportunities. Almost all of them are going to require really in-depth analysis of facts and law to see how these structure ideas might apply to you. But I think that it'll be profitable, and we've found with all of these structures that there are a couple or three examples of situations that we've been involved in where this approach has been useful. So the first one I want to jump right in and start talking about is hospital investment in a clinic. And this happens when a hospital says, we'd like to do something together with a group of physicians. It's a joint venture of sorts, and we want to know whether we can do it. And the first barrier to doing anything like this is compliance with the Stark Law. And you'll hear us today talking, as I'm sure you're used to hearing people talk, about the Stark Law and the anti-kickback law and tax exemption rules and a whole host of sort of related regulatory frameworks. But what we typically find is that with the Stark Law, which is a bright line test with technical rules that you have to comply with, you analyze the rules very deeply to try to ensure that you've got a good approach to compliance. Anti-kickback, on the other hand, is really focused on the party's intent. And so where the Stark law analysis is inherently kind of legal, the anti-kickback analysis is inherently kind of factual. So leading a lot of these approaches is going to be how this works under the Stark law. So this idea is that the hospital, instead of creating a separate joint venture with the physician, says, well, why don't we invest directly in the physician's clinic? The resulting structure is a little bit like what's on your screen now. The hospital and the physicians each are co-owners in the clinic. So why is this useful? Well, the Stark law has a number of exceptions, and the exception that's probably the most powerful of all is the in-office ancillary exception. It's the most powerful because it applies to both compensation arrangements and ownership arrangements, and also because it's structured to be a little bit different from all the compensation exceptions. The Stark law exception says the prohibition doesn't apply to services that are described as set forth in the requirements. The compensation exceptions really are focusing on the economics of the arrangement, and the in-office ancillary exception really isn't. It's really focused on the structure. So the Stark law says the prohibition on referrals doesn't apply to in-office ancillary services, and then there's a long list of requirements as to what is an in-office ancillary service. And I'm not going to list all of them. We could go on for an hour talking about what are the requirements of the in-office ancillary service. But the key to it is that they are billed by the physician or they're billed by the group practice. So if you have a service that's happening inside the group practice, that service is an in-office ancillary of that group practice. And so then the question is, well, what is it that you have to do in order to be a group practice? Can you be a group practice if you've got a hospital owner? So a group practice, among its other requirements, is that it must be a single legal entity, and I'm reading under the second bullet point here, operating primarily for the purpose of being a physician group practice in any organizational form recognized by the state. So you can be a partnership, an LLC, a professional corporation, and that's what most physician clinics are. Doesn't say that you can't have ownership that goes outside of the physicians who are participating in the group. Also, a group practice that is otherwise a single legal entity may itself own subsidiary entities. So this question, what is a single legal entity, is a question that's somewhat fraught. It isn't clear exactly what's a single legal entity, but we know we have some room, and we know that a single legal entity may itself own subsidiaries. So that's the sort of stark underpinning of the idea. The idea is that instead of creating a separate joint venture, the hospital simply finds a mechanism or a method of investing in the clinic itself. So that's stark. What about some of our other laws? Well, if the structure that you create seems like it's a separate entity, it's probably not going to meet the small entity safe harbor. And as I've said before, intent is the key to anti-kickback analysis. So what you would typically do is take a look at all the facts and say to yourself, do we have something where this investment by the hospital in the clinic appears to be intended to induce the referral of program-related business? It's always useful to meet as many requirements as possible, and it's really important that whatever happens in a hospital investment in a clinic, it doesn't involve a sweetheart deal. The hospital has to be getting value for what it's contributing, and that runs through the anti-kickback law, also the tax exemption laws. But because we're focusing on sort of what are the creases in the legal analysis, the technical legal analysis, I'm going to sort of move away from that. Now, there's another regulatory framework that governs physician practices, and it is this corporate practice doctrine. Can the hospital own an interest in the clinic? That's a really good question, and it's one on which state laws differ. You find some states that will provide authority for a hospital directly to invest in a clinic. They are their own exception to the corporate practice doctrine. There are some states that say it's okay to have non-physician owners as long as they don't maintain governance authority that involves clinical decision-making. It may be that a state requires investment by another professional corporation and that somehow a hospital can create one. For example, some states allow a nonprofit professional corporation which can be owned by a state. And there are some states that would say a nonprofit can own or that a nonprofit can directly provide certain services. Now, corporate practice will have an effect on the way you participate as a hospital owner of a physician clinic if you're trying to develop this idea a little bit further. And there's sort of three examples of ways that you might structure that I want to go through briefly. First, this is sort of the most obvious. The hospital purchases Class B shares of the clinic, and the clinic has generally the ability to establish different classes of stock. It's important that this not be the approach if it's an S corporation. S corporations don't have multiple classes of stock, but what happens is that the clinic sets forth a resolution which gives rights and preferences that are attached to these Class B shares. And the Class B shares could be almost like a little description of a partnership. The profit and loss that's related to JV operations, whatever is jointly shared by the two parties, can be attached to the Class B shares. Similarly, there can be a separate buy-in to these shares that might be separately valued if the interest is not in the entirety of the clinic. The Class B shares have to be designed with the thought how they get bought out at the end of the investment. Are they preferred shares? Do they come ahead of the other shares? Do they come behind debt in the event of any dissolution of the clinic? Are they convertible to some other interest? Is there a withdrawal that's permitted by the hospital? All those things are complex issues and really will be important and what will be important in determining which ones how to do it is what are the facts. Finally, will the Class B shares have governance authority? Typically, a hospital investment in a for-profit entity needs to be one where there is proportionate ownership and governance, and that proportionate ownership and governance is related to the level of the investment. Okay, that's sort of the overview of Class B shares. Another approach is to create a partnership. Now, a partnership can be a complicated topic even for lawyers because a partnership is thought of in one view as a separate entity and in another as really the aggregation of the partner's activities. And under the Stark Law, in order for this to be a group practice, the enterprise has to be billing in the name of the practice. And that's probably permissible in most places, even if the resulting revenue is being shared through a partnership. I've seen situations where an arrangement is set forth in a contract that's essentially a partnership, but one partner, the group practice, is billing for the benefit of the partnership. And that's something that might give some complication. Is there one entity or are there multiple entities? I think that there's a strong argument that it is a single entity or that it is a single entity with a partnership that is like a subsidiary. Again, the corporate practice rules are important, and that's something for local consideration, but the question is, can the hospital be a partner with a professional entity? might depend on what the activities are that are being housed inside that venture. Might be that there is no particularly clear rule and that you have to try to figure it out. A third approach that people don't think about very much is participating debt. And that really is sort of like Class B stock. What you do is you issue debt and you say the return on the debt is based in part on profit and loss in this particular venture. The Stark Law, interestingly enough, considers certain debt, secured debt in particular, to be ownership. And clearly, echoing what we said before, there can't be a sweetheart deal if somebody created this kind of participating debt. But the idea of all three of these approaches is that the activity is being carried on by the group practice. The group practice has this very powerful Stark Law exception that it can use, and as a consequence, the thing is okay from a Stark point of view. So there are some examples that I've seen. Sometimes a hospital says, I want to work with a local clinic to establish a new clinic location. Sometimes that happens when the hospital is lacking a specialty. What really is interesting to the parties is having a particular office. That office could be a joint venture of this kind. That's a true physician, licensed professional idea. Another idea is simply for the hospital to invest in a clinic that wants to retain independence, doesn't want to be bought by the hospital, but really needs to have some kind of infusion of capital. So, investment in the clinic is a strategy that's available. It seems like it has an avenue of activity under Stark. There are lots of different forms and approaches, and I'm going to say this more than once. Don't do this at home. You've got to think about this with a lot of professionals. Bring your lawyers and accountants to try to figure out how it would work. But all of those approaches are possible. Okay, we're going to go on to a second idea. This is a bit underused because people don't like that first word, nonprofit. But nonprofit entities are useful vehicles for a venture, and the reasons are similar to some of the reasons we were talking about before. They're the corporate practice rules and the Stark rules. The Stark rules contain a prohibition on ownership for certain folks. Nonprofit entities are not really owned. They're not inside the definition of ownership. Corporate practice also restricts ownership in certain ways. It's the opposite way. It prevents the hospital from owning. Let's talk about those two issues. Corporate practice. Typically, corporate practice rules that say only a physician can own a licensed physician clinic are less rigid in the context of a nonprofit. And I mean, part of the reasons for this are that the nonprofit is not supposed to distribute its profits to anybody other than another nonprofit. And the nonprofit isn't owned. So the part of governance that comes from ownership just doesn't exist. So corporate practice doctrine may allow more opportunity. Some states specifically allow a non-profit professional corporation, which sounds like an oxymoron. But the fact that that's true, Minnesota is a state that does that, by the way, may mean that a venture could go searching for an appropriate entity in another state, just as people sometimes use a Delaware corporation. You might be able to create a nonprofit PC in another state and have it operate in your state. Some states also explicitly permit a nonprofit to practice a profession. So it's also important to understand that this approach isn't just for licensed professions like a physician's clinic. it could be an approach that you use in a technical service venture, and hospitals generally can participate in those unlicensed activities. That means, by that I mean activities that aren't only permitted under a physician's license. If you have a nonprofit entity that you use in a joint venture with a physician, it means you have a multi-part financial relationship. Nonprofits typically cannot make distributions to anybody other than a nonprofit. I said that in a more positive way in bullet number 1, that they can typically make distributions to other nonprofits, but they couldn't make distributions to private owners like physicians. But private owners like physicians can receive reasonable compensation. And, you know, we all know how reasonable compensation is established. You look to what private parties would pay or receive for similar services. You have to make sure that that's not based on referrals. And you probably key off of some kind of outside survey information. Note, you can pay for management services just as you pay for professional services. This is a Stark Law opportunity, and one of the reasons it's a Stark Law opportunity is that Stark doesn't permit much in the way of ownership by physicians of a joint venture in an urban area. And so you might say to yourself, well, then we won't have them own. We will have them participate as recipients of reasonable compensation. Anytime you set up a nonprofit, you have to say to yourself, do I want this to be a taxable nonprofit or an exempt nonprofit? People get confused about this. They tend to use the word nonprofit when they mean exempt. Exempt entities are subject to quite extensive regulation, including the private inurement, private benefit rules, intermediate sanctions. General nonprofits, taxable nonprofits, not really regulated very much. In many cases, an attorney general has an interest in making sure that the nonprofit isn't giving away the public trust that it is important to it. The other thing I think it's important to say is that exempt entities may fundraise. So if you have a notion that you want to operate an exempt entity and fundraise to support your mission, then it makes sense that you would be exempt. My thoughts are, in general, you're going to avoid exemption. There are lots of examples of the use of nonprofits. For one thing, hospitals that are joint venturing with other nonprofits typically use nonprofits. So I have seen a situation where a hospital is joint ventured with a nonprofit health plan, for example. Similarly, sometimes a nonprofit status is useful to obtain preferential reimbursement. That happens sometimes for dental providers, for example, operating low-income clinics. Also seen it used in the connection of a hospice establishing a related clinic, a palliative care clinic. That's a venture that is outside the normal scope of the hospice's activities, and the nonprofit approach proved workable. So it's a useful Stark Law strategy. Corporate practice can be an issue, but it also can be something that can be worked with by nonprofits, sometimes better than for-profits. All right, Ryan's going to take it from here for a little while.
All right, let's talk about ASCs, or ambulatory surgery center joint ventures. One way that physicians and hospitals can partner with is in ambulatory surgery centers. As we'll talk about in a few minutes, Stark does not include ASC services as Stark DHS. There's more flexibility for the parties to structure joint ventures in a relatively risk-free way. So the key regulatory issues when you're structuring physician-hospital joint ventures include various federal laws, including the anti-kickback statute, which Steve talked about, the Stark Law, antitrust laws, and tax exemption laws if you have charitable organizations involved in the joint venture. So since Stark is not as important in physician-hospital ASC joint ventures, the key analysis typically focuses on the anti-kickback statute. Now, luckily, the anti-kickback statute does have safe harbors for several different types of ASC arrangements, including surgeon-owned ASCs, single-specialty ASCs, multi-specialty ASCs, and then hospital, physician, jointly owned ASCs. Now, as most of you know, you don't need to be in a safe harbor under the anti-kickback statute. It's nice to be in one. Creates some certainty about risk under the anti-kickback statute. Many arrangements are not within a safe harbor, but it's nice to be within one if you can be, or incorporate as many elements of the applicable safe harbors as you can. So the key elements of the ASC safe harbors include the following: that investment or equity not be related to the volume or value of referrals or distributions from the entity, that there are no loans or loan guarantees by other investors, that distributions to the owners are directly proportional to the amount of the investment, that with respect to ancillary services, they're directly and integrally related to primary procedures performed at the ASC, and that none are separately billed to Medicare. You must also treat Medicare patients in a non-discriminatory manner, and patients of the ASC must be fully informed of physician's ownership in the ASC. Now, there are two 1/3 tests that are often used in ASC joint ventures. One is for single-specialty ASCs, and that requires at least 1/3 of each physician investor's medical practice income from all sources for the previous fiscal year or previous 12-month period be derived from the physician investor's performance of ASC procedures. And the concept here is you want to make sure that the physician investors are not just passive referral sources for the ASC, but they're actually using the ASC as an extension of their practice. And so these tests are designed to make sure, again, that you're not just bringing in investors to capture the referrals to the ASC for ASC procedures, but really the physicians who are investors are using the ASC to treat their own patients for surgical procedures, ASC procedures. The other 1/3 test is for multi-specialty ASCs, and that includes the 1/3 income test, which is above in the first bullet point, as well as the requirement that at least 1/3 of the ASC procedures performed by each physician investor for the previous fiscal year or previous 12-month period be performed at the ASC. And again, these requirements are for the safe harbor. The safe harbors under the ASC, for ASCs under the anti-kickback statute. Not all ASC joint ventures are structured to comply with the anti-kickback safe harbor. Those that are structured that way are protected under the anti-kickback statute. Those that aren't, they might involve more risk. I'm certainly aware of many ASCs that try to incorporate as many elements of these safe harbors as possible, but don't include all of them. So the most important point here, I think, is that ASC services are not Stark DHS, which again provides a relatively clear pathway for structuring joint ventures under the Stark law for hospital physician ASCs. A note on payer contracting for ASC joint ventures and antitrust. In many healthcare joint ventures, including ASC joint ventures, the participants often agree to have one of the owners handle payer contracting. Oftentimes, hospitals, they have better contracts with payers. Now, these joint ventures have to be analyzed under applicable antitrust law, including this Section 1 of the Sherman Act, which prohibits contracts, combinations, or conspiracies in restraint of trade. And there are certain per se violations, including price fixing, allocation of territories or customers, etc. But a violation of Section 1 of the Sherman Act requires an agreement between two or more economic entities which has an anti-competitive purpose. Under the Copperwell Doctrine, the Supreme Court looked at whether a parent and a subsidiary should be deemed to be separate legal entities under Section 1 of the Sherman Act. And what the Supreme Court found is that they'd be deemed to be one entity if there was a union of economic interest, common and not disparate objectives, and corporate actions were guided by a single corporate consciousness. So in ASC joint ventures involving a hospital and a physician group, if one of those parties will be doing payer contracting, it's important to make sure there's sufficient unity of economic interest so they'd be deemed to be one legal entity under the Copperwell Doctrine for purposes of the antitrust analysis. Without that, there could be per se violations under Section 1 of the Sherman Act. Now, if the Copperwell Doctrine is satisfied, the arrangement then has to be analyzed under Section 2 of the Sherman Act, and that focuses on monopoly power. Oftentimes joint ventures involve competitors or would-be competitors in a certain market, and again, because of that, you have to consider antitrust issues, not just the per se violations, but also the concept of monopoly power, looking at the geographic market and the types of services that are being provided by the joint venture to make sure you don't trigger any other antitrust issues for the parties. So some closing thoughts on ASCs. One of the most important issues in structuring joint ventures is investor selection. The key part there is making sure that investors are not being selected solely because of their ability to bring or refer cases to the surgery center. The extension of practice-based safe harbors we talked about earlier, again, are important, I think, for guiding investor selection of physician investors. Valuation is very important to make sure that ownership is only tied to the respective contributions of the investors, not tied to the volume or value of referrals. Co-location, one thing that some of our clients have investigated is looking at whether an ASC can lease space within an existing healthcare facility, including perhaps another ASC, or lease to another healthcare facility or clinic. Now, the federal Medicare and Medicaid laws require that ASCs meet the following definition, and that's a distinct entity that operates exclusively for the purpose of providing surgical services to patients not requiring hospitalization, in which the expected duration of services would not exceed 24 hours. Now, the key part of that is that it has to be a distinct legal entity. And the way that's been interpreted is that the ASC will be a distinct entity if it's wholly separate and clearly distinguishable from any other healthcare facility or office-based physician practice. Now, where permitted by state law, Medicare would permit several different ASCs, regardless of their specialty or Medicare participation, to use the same physical space, including the same operating rooms, so long as they're temporally distinct, that they do not have concurrent or overlapping hours of operation. And if that's possible with some ASC arrangements. So in the morning, one ASC would use the space, in the afternoon, the other, for example. It's important that each of the ASCs would be separately responsible for compliance with state and federal law. And those co-located ASCs could use the same nursing or other staff under arrangement, but they're each required to separately comply with all the requirements governing the utilization of staff in the ASC. So co-location has been an interesting model for some of our clients. Hotels, some ASCs have entered into arrangements where patients can stay at hotels following a surgery at the ASC, and those hotels would have, will provide various home care, healthcare services to their patients. Moving on to under-arrangement deals, which I think Steve will talk about.
All right, so this is another place where the law has an interesting wrinkle. There are all kinds of reasons why a joint venture to provide a hospital service can't be put together. There's a complicated set of rules that govern outpatient hospital services. That's the entities and departments that make up the hospital outpatient service. And in general, those can't be done off campus. Joint ventures could never be done off campus. Joint ventures could conceivably be done on campus, but there's a prohibition on physician ownership of a hospital, and when there's a joint venture that's on campus, it's considered to be physician ownership of a hospital and therefore subject to the prohibition or related grandfathering rules. And there's also a stark concern that the physician, if a physician owns a hospital, he would be prohibited from referring anything to the hospital. So under the sort of normal approaches that one might expect, physician ownership of hospital-based services is very difficult. However, a hospital can provide a service directly, or it can enter into a contract with somebody else to provide the service to its patients under arrangements. The hospital bills for the service and then pays the outside provider of the service. And the consequence of that is that you can consider putting together a structure kind of like this picture. Hospitals and physicians get together to create a joint venture. The joint venture enters into an under arrangements agreement with the hospital to provide the services. It gets paid by the hospital to provide the services to the patients. It doesn't have the right to bill separately. The hospital does the billing. So the hospital department or entity rules don't apply to a under arrangement service. And as I said, those rules are incredibly complicated. They're, 30 pages of tiny print. The under arrangement rules are about 2 paragraphs. The hospital has to have governance of that contract, and essentially the services have to be documented in the hospital's medical record. A very simple procedure to obtain under arrangements treatment where the hospital gets the right to bill. The prohibition on physician ownership in hospitals has an explicit exception for under arrangements deals. That means that this significant blocker to physician ownership of a hospital billed department or a hospital billed service is not applicable to this kind of an approach. Stark issues. Physician ownership is only permitted in rural areas, and so that leads you to a question: ownership of what? And people, I think, probably still remember that if an outside party provides the entirety of a service, and people think of that as the technical wherewithal plus the professional skill, then that entity is the owner, or that is the entity considered by Stark in addition to, in this case, the hospital. So in a situation where the joint venture is providing the entirety of the service, Stark would say this only works in rural areas. If the hospital is providing a portion of the service and the facts are such that the under arrangements rules apply nevertheless, then the entity is just the hospital and the physicians don't own the entity. In that case, this approach might be workable in a non-rural area. Under Stark, the ownership test has to be dealt with, and that's what we just talked about, but also a compensation arrangement exists, and the compensation arrangement is the under arrangements contract. And so where the hospital's purchasing services under arrangements, the exceptions for compensation have to be met, and they're somewhat specialized. Service arrangements can be per click. Lease arrangements can't be per click. So the structure has to separate these elements. It has to say if you're providing a given service to the hospital under arrangements and it contains real estate or equipment, that real estate or equipment needs to be paid for on a per time basis or a flat fee basis. And the service arrangements can be per click. Fair market value then becomes the key issue under the Stark analysis. This fair market value can be very difficult for services that are not physician services, there isn't necessarily an outside survey that you can point to justify the level of compensation and make sure that it's fair market value. And the idea is that fair market value means the payments between two unrelated parties, not including parties that are in a referral relationship. Well, it's hard to imagine very many situations that exist in nature where there isn't a referral relationship in this kind of context. So fair market value might have to be sort of derived synthetically from an analysis of what each party is getting out of the deal. And that's probably the most difficult part of this kind of an arrangement. As we've said before, we can't just focus on Stark and ignore anti-kickback. If you have, for an example, a hospital that wants to joint venture a diagnostic service with a clinic, the question is, in part, why are they doing it? Do they need the capital that the physicians are able to provide? Do they need the expertise that the physicians are able to provide? Are they trying to do it in sites that are sites that the physicians have some unique control over? There is a concept that's more than a value concept. Is this arrangement commercially reasonable? And that concept is in anti-kickback and Stark, and it really goes in the anti-kickback analysis to what is the intent of the parties. Clearly, it can't be even one purpose of the parties to pay the physicians to refer either to this joint venture or other patients to the hospital. But in lots of rural areas, there aren't very many participants in the healthcare system, and they may say, we need to put together a service that we can't otherwise support. So let's figure out how to do that. So lessons learned. The under arrangements idea is this very powerful idea in a thicket of regulations that restrict the other obvious way to try to achieve this idea. All right, I'm going to talk about the next thing. That's really hospital payer co-ownership. And I want to talk about co-ownership, just like this picture with a joint venture, as something that's different from creating a network. It might include a network, or it might include some kind of provider contract arrangement between the payer and the provider. But the notion of this is co-ownership, and it really starts with this idea that we hear from all our clients that what we're trying to do is enter into a new world where there are aligned incentives. The question is really, what are aligned incentives? And you see a couple of ways that people try to align the incentives. One is, well, let's create a network, and the network will make adjustments to payments. You get a fee-for-service payment, but there's a positive or negative adjustment based on your performance against a total cost of care target. So does that really align the incentives? What are the incentives for the payer and the provider with that kind of an arrangement? Well, the payer's incentive is to reduce the medical cost. The provider's incentive is to reduce cost, but not the cost of its own services. If you get paid $100 for a service and you eliminate that cost, and now you get $50 because you're splitting 50-50 against a total cost of care target, you didn't help yourself. So the alignment of incentives isn't very perfect in a total cost of care adjustment network model. What about in a capitation model? That's what people often think about if they're not doing something that's as simple as a total cost of care adjustment. Well, the payer is truly incented to pay a capitation that's less than their fee-for-service pay structure. They want to save money. That's really all they are, is a financing vehicle. Again, the provider is incented to reduce cost, especially the cost of other providers in the pool. And if you're paid a pure capitation, you don't have a direct incentive to keep your costs in play as you do with the total cost of care model. But it's very difficult to act differently, behave differently in the capitated part of your business than you do in the fee-for-service part of your business. So most folks really are trying to figure out how to reduce the cost of other providers in the pool. Another thing that is absent from most of these incentive aligning arrangements is payer responsibility for the provider's economic results. If the provider becomes focused on saving certain kinds of costs, that achieves a measure of alignment, but it may be that the provider in so doing creates a loss that might be disastrous for that provider. And most alignment arrangements don't look at the results from the point of view of both of the participants in the relationship, the provider and the payer. And so some folks now are looking at ways to create payer ownership of part or all of the provider. And that payer ownership puts the payer in the position where the payer is actually responsible for some provider losses or gains, gets responsibility for gains. And as a consequence, there's sort of another element of symmetry between the parties. There's another kind of alignment that's added to the mix. It happens either with that second bullet, payer ownership of part of the provider, or it happens with a contract that approximates the financial results of ownership. And clearly, a contract can say, if you lose money for the following purposes, we will support you. Now, there are a whole lot of things that make it difficult to bring in an outside, generally taxable and maybe for-profit entity as an owner of a hospital provider. One is just the need to preserve the hospital's tax exemption. There's an analysis called the Redlands analysis that basically says if you have an ancillary service, it's not really a significant part of your business, you can enter into a joint venture for that, and you don't have to, as the exempt entity, maintain total control, maintain majority control. However, if you're a whole hospital, or if you're a significant part of the hospital, not an ancillary part, then you do need to be the majority owner and maintain governance. If there's a professional practice involved, then there's a corporate practice issue. Can this entity participate in a way that is permitted by state law under the corporate practice rules? And we've talked about that a little bit before. It may be that it's useful to use a nonprofit structure to benefit your position under the corporate practice rules, and it may be that you have to do something else. Depends on the state. Conflict of interest is an issue that some states might be interested in, and this is the idea that there might be a conflict of interest between payers and providers inherently. Choice of entity, most likely that's either a nonprofit, and we'd go through the nonprofit analysis, or it's an LLC. And the LLC has the advantage that the exempt entity is pass-through of or allocation of profit and loss is treated as tax-exempt, and the other is treated as taxable. And then governance issues. Each party will want to preserve its separate interest. This kind of arrangement may also involve the development of a network, and network arrangements contain the kinds of issues that you might be very familiar with. You've got to make sure that a non-insurance company isn't issuing insurance or acting as an insurer. Got to make sure that in making distributions or other financial benefits to network participants, we aren't running afoul of any anti-kickback and Stark issues. And we want to figure out how other providers will participate. Probably worth mentioning that network arrangements may require financial or clinical integration to avoid antitrust complications, and if they're sharing information in order to achieve clinical integration, they may need to deal with the HIPAA rules. Ryan?
Oh, one more. All right, so I'm going to talk about professional service agreements. As background, from the beginning of Stark, many healthcare providers and their counsel have preferred employment arrangements for physicians because of the relative safety and clear pathway provided by the Stark exception for employment-based arrangements, as well as the safe harbor under the anti-kickback statute. The obvious alternative to an employment arrangement is an independent contractor agreement, and a professional service agreement is one version of an independent contractor agreement. Independent contractor agreements do involve more risk under Stark and a kickback statute. And professional service agreements, or that label, doesn't involve any special magic that makes these risks disappear. Again, PSAs are simply independent contractor agreements for the provision of medical services, and they typically involve the transfer of billing rights from physicians or physician practices to hospitals, with physicians getting paid for their professional services. Now, structuring these arrangements incorrectly can create significant risks to the parties, to the PSA, and it's important that the arrangements be structured to comply with applicable law, including the Stark law, which we've been talking about today, the anti-kickback statute, the tax exemption requirements if you have a charitable, hospital in the arrangement. So why do we use professional service agreements? Again, it's one alternative to an employment-based model that's sometimes preferable to physicians and the hospitals. PSAs can also streamline billing processes, expand services to patients, and provide greater flexibility to the parties to the arrangement and potentially lower costs. So the critical terms that you include in a typical PSA include, of course, the term, termination rights. The arrangement could be exclusive or non-exclusive. Compensation is important, of course. The parties often include non-competition provisions or other restrictive covenants, including non-solicitations, no hire clauses, and of course include performance standards. So I'm going to jump ahead to some of the tax exemption requirements, so we hopefully leave some time for Q&A at the end. If you have a tax-exempt hospital or clinic involved in a PSA, it's important to remember that these entities must operate exclusively for charitable purposes. There could be no private inurement, or private benefit. At the high level, the most important thing is to make sure that the compensation paid to the physicians is fair market value. Ideally, it's determined via appraisal by an independent third-party valuation firm. Some questions to consider. Should there be a cap on compensation? What happens if a practice loses money? Then how should it be compensated? What compensation model will be used? Often it's RVU based, it's production based, sometimes grossed up to include other costs to the practice, including tax and benefits for the employees, certain retained practice expenses, et cetera. But again, the most important thing is that the compensation paid is fair market value. Now, part of the analysis is often looking at both pre and post-closing compensation for the physicians. If the physicians in the arrangement go from making, say, $100 per RVU before the arrangement and jump to $200 under the arrangement, that raises questions. And again, it requires a close look at whether the compensation being paid is fair market value. And not only for the rules applicable to charitable organizations, but also because of the Stark law and the anti-kickback statute and any state analogs. It's important to take account of any existing agreements when structuring PSAs. If a hospital and physician group have other agreements, medical director agreements, co-management agreements, et cetera, it's important to make sure that there's no double dipping or double payment for the same services. So doing some due diligence, making sure you understand all the arrangements that are in place to make sure that under the PSA and the other agreements, the physicians are only being paid fair market value compensation is important. With some PSAs, tax-exempt bond issues can pop up. Tax-exempt and government organizations often use tax-free bond financing for their infrastructure, but these bonds often come with some significant strings attached, both governing how money is spent, but also on the operations of the entity that's benefiting from the tax-exempt bonds. One of these restrictions is on the prohibition on private use. So in structuring PSAs, it's important to make sure that the physician's use of any hospital or tax-exempt space would not be viewed as impermissible private use under the rules applicable to tax-exempt bonds. So there is a safe harbor for personal service agreements, and oftentimes PSAs are structured to fall within the safe harbor of the anti-kickback statute for personal service agreements, or incorporate as many of the provisions as possible. Some of the key requirements include that be in writing, cover all the services provided, be for a term of at least 1 year. And again, number 5, it's important that compensation be set in advance and be consistent with fair market value. It does not take into account referrals between the parties. Now, meeting each of those provisions under 5 can be challenging under some of these arrangements. But again, it's preferable to have an independent third-party evaluation firm, really look at compensation to make sure that it's consistent with fair market value, and consider putting a cap on overall compensation as appropriate. So under the STAR clause, also an exception for personal service arrangements. It's very similar to the anti-kickback safe harbor. It must be in writing, term for at least of a year. And again, number 5, compensation must be set in advance, not exceed fair market value, and not take into account referrals between the parties. And again, since hospital services are DHS and the PSA creates a financial relationship, it's important to make sure that any PSA be structured to comply with the applicable Stark exception, and the one that's often used is the one for personal service arrangements. One other issue that's important to think about is the group practice definition, and Steve talked about this earlier. Many physician practices rely on the Stark exception for in-office ancillary services, which allows the groups to provide certain Stark DHS within the practice. But to qualify for that exception, the group must meet the definition of a group practice under the Stark law. And one of those requirements is that substantially all of the patient care services of the physicians who are members of the group, as at least 75% of the total patient care service of the group practice members, be furnished through the group and billed under a billing number assigned to the group, and the amounts received must be treated as receipts of the group. So it's important to make sure that any PSA be structured to protect the in-office ancillary services exception if during that arrangement the physician practice will continue to rely on that. You don't want to somehow screw up the operations in a way where the practice no longer qualifies for that exception because it's no longer a group practice. Now, some other language to take into account when structuring these. If the group's business includes providing professional services to another entity, which in turn pays the group for those services, for example, a PSA, the view of the regulators that these services should count as services a physician provides through the group. And so there are opportunities to structure the PSAs in a way that, again, allows the physician practice to continue qualifying for the in-office ancillary services exception. But the important thing is to be aware of the group practice definition and make sure the activities, the billing, et cetera, are conducted in a way to protect that exception. It will continue to be relied upon during the term of the PSA. Again, don't forget state laws. Many states have their own version of the federal anti-kickback statute, their own self-referral prohibitions, fee-splitting laws. These apply to PSAs and many of the rates we've talked about today. I'll stop there because we're getting to the bewitching hour, see if there are any questions from attendees. Steve, any thoughts?
I have one clarification question that somebody asked, and otherwise I think we will let you go, and that is Just what do I mean when I say a PC? It's important to understand that a professional group, professional corporation, or professional association, PC or PA, operates under physicians' licenses. Other kinds of providers operate under separate facility licenses. And those PAs or PCs in most states are only permitted to be owned and governed by licensed professionals, physicians, or other kinds of professionals. So they've got their own separate regulation, which is causing some of the heartache. When we talk about the corporate practice doctrine, we're talking about the restriction to physicians as owners or governors of those entities. I guess we're out of time. Everybody make sure that you put on your calendars February 19th, where we will have a cast of thousands talking about the opioid issues.
Very good, thank you.